Hello and welcome. This video has been prepared by the City Bar Justice Centre's Cancer Advocacy Project and is part one of two informational videos that are intended to provide you with a simple overview of the main documents used for life planning, which is also called estate planning. This information is based on New York law and is not intended to substitute for legal advice. The main life planning documents are wills and advance directives, which allow you to name a person of your choice to speak or act on your behalf if in the future you become unable to handle your own affairs directly. In preparing a will, as well as stating who should receive your property, you would name someone to be your executor to settle your estate after you pass away. In your advance directives, you would name an agent to handle various matters for you, including medical and financial issues according to your wishes. Maintaining a sense of independence and control over your affairs is especially important when you've been diagnosed with a serious illness like cancer. Whether your diagnosis was recent or in the past, preparing these documents in advance means that your affairs can continue to function efficiently through the person that you have chosen for that role. This video, part one, provides a simple overview of wills. A separate video, part two, focuses on advance directives. Many people assume that you only need a will if you have a lot of money or property, and if you don't, then it's all right to handle things in an informal way, such as, well, I don't have much, so my kids can just divide it up however they want to. Or, I've left a letter in my desk drawer with my instructions. Or, everyone already knows what they're getting. But relying on that type of informal arrangement is not the same as preparing a will, and it can result in complications, including serious family disputes over property, which may end up in court. So even if you believe that you don't currently own anything that's worth leaving in a will, most people do have something that would be of value to a friend or family member, such as a piece of jewelry with sentimental value, or family photographs, or you may even be lucky enough to win the lottery or inherit property from someone else. No one knows what they'll own at the time they pass away, so you should document your wishes. Among the reasons for making a will are verbal promises are not enough when leaving property, and it could result in disputes and litigation. With a will, you leave clear instructions about who should get your property. They're called your beneficiaries. Don't assume that your family will be able to agree on how to divide up your property without something formal like a will in place. And you'll be able to name an executor to take care of settling your estate and distributing your property according to the instructions in your will. And if you have a minor child, you can name a guardian to protect and provide care for that child. So what happens if you pass away without a will? That's called intestacy. So you would have died intestate. And in that case, your property will be distributed according to the legal rules that specify the order and the shares in which the property will be given to your heirs. So your heirs are your blood relatives. However, the result may not be what you would have chosen. So, for example, by law, if you have children, each one will receive an equal share of your estate. And that may work well for some families, but not for others, such as where one child is doing well financially while the other is struggling. With a will, you can be more specific and targeted about who will receive what property. Also, under intestacy, the law does not include friends or other non-family members in the list of people who are heirs, who can inherit. So if you would like to leave something to a friend or a charity, you must do that in a will. And if you have no surviving relatives that can be located, your property will be forfeited to the state. So it's certainly better to prepare a will and leave it to a friend or a charity. And finally, the court will appoint an administrator to settle your estate, and their role is similar to an executor who is appointed under a will. So there are some important things to keep in mind as you prepare to make a will. You must have testamentary capacity to prepare a will, which means that you understand the purpose of a will and the consequences of signing one, that you have awareness of who your closest relatives are, and that you know what property you own and who you want to leave it to. A person who does not have testamentary capacity, perhaps because of Alzheimer's or dementia, cannot prepare a will. And with a few limited exceptions, you cannot disinherit your spouse. A spouse has certain legal rights to your property, whether or not you mention them in your will, and that is called their elective share. So a spouse can choose or elect to make a claim for a share of your estate after your death. They may decide not to do so, but in general, they do have that right unless you were legally separated or divorced before your death. Also, you must specifically state in your will if you intend to disinherit close family members, especially if it's your child or children. Do not just fail to mention them in the will. And also, the decisions in your will must be made by you, with no influence or pressure from anyone else. Those must be your choices. So one of the key decisions when making a will is choosing your executor. An executor is the person who will take care of settling your estate after you pass away. So some examples of their duties, their tasks, include submitting your will to the surrogates court, which handles the administration of estates when someone dies, notifying certain third parties that you've passed away, for example, your bank or your pension fund or Social Security. They have to pay your outstanding bills from your estate, out of your estate. So that can be bills such as funeral expenses or taxes that are due. And they have to distribute your property according to your will. Your choice of executor is important, so do choose someone who is reliable and organized. You do also have the option to choose a co-executor, which means you can have two executors working together at the same time. However, keep in mind that co-executors must work efficiently together. So unless you're absolutely sure that they can do that without any disagreements, it's better to appoint just one person as the executor and the other one as a substitute executor who can step in if the executor cannot serve when needed. You may not need to include all of your property in your will. Some types of property should be included in your will, while other types may pass to your beneficiary automatically, whether or not you have a will. So some examples of property that should be included in your will would generally involve any property that you own by yourself. You are the sole owner of that property. So for example, a house or a condominium or land where you are the sole owner. There is an exception for where you have a joint ownership if it is a tenancy in common. And in that situation, if you own property with someone else under a tenancy in common, you are able to pass your share of that property to someone else in your will. If you're not sure what kind of ownership you have of your property, you should take a look at the title deed so that you are sure of what it is. And in that way, you'll be able to know whether your property is the kind that can be included in your will, or if it's going to pass automatically. Another type of property that you should put in your will is if you have a bank account that is only in your name and that you have not named anyone on it as a beneficiary. So if your bank account is in your name only and no one else's name is on it at all, then that you will need to deal with that in your will. In a similar situation, any financial account that does not name a beneficiary, like a life insurance policy or a pension account, that would have to be included in your will. Any personal property, such as jewelry or clothes, a car, if that is yours alone, not shared, not jointly owned with anyone else, that would be in your will. So property that will pass automatically to a named person and does not have to be in a will includes a house or condo or land that you own with another person as joint tenants with a right of survivorship, or as a married couple with the ownership as joint tenants by the entirety. Also, if you have a bank or other financial accounts that you hold jointly with someone else or on which you have named a beneficiary, or property held in a trust, that type of property does not have to be included in your will because somebody is already named who is either a joint owner or you have named as the beneficiary. So once you've prepared a will, there are a few other things that you need to be aware of. So in your will, some people choose to put their funeral and burial wishes in that will. However, whether or not you do that, your funeral and certainly your burial wishes should be in a separate directive. So that directive is called a disposition of remains, and it's included in the advanced directives video. But rather than just leaving that kind of direction in your will, it should be in a separate directive, which can be used for that specific purpose to organize your funeral and burial arrangements. You should also think about discussing your funeral and burial wishes with your family so that everybody understands what you want. And if you would prefer to pay for your burial expenses in advance, perhaps so that your family will not have those costs, or if you do not have any family to help, one option is to purchase a prepaid burial plan with a funeral home that you can pay off in installments. You should also review your life planning documents every year or so to check that they still reflect your wishes. And you should keep your will in a safe place and let someone, particularly your executor, know where it is. Do not keep it in a safe deposit box, for example, in a bank, unless someone else also has the right to access that box, even after your death. So, I hope this summary has been helpful in explaining why having a will is an important part of being prepared for whatever the future brings. You decide who should receive your property, which can include friends and charities, rather than leaving it to the rigid rules under the law. It also enables you to state your wishes about other important matters, such as guardianship of a minor child. A summary of advanced directives can be viewed in part 2 of the Cancer Advocacy Project's life planning videos. Information about the Cancer Advocacy Project is provided on this slide and on the following one. Thank you for watching.